paragraph 2, we just highlight that the synonyms for the word representations do include pictures and symbols and images. So the department is quite satisfied, Mr. Chair, that the definition of data will include pictures. Now, if I would like to go to the characteristics tables.
Before you proceed, I think the question was asked by Honorable Newport Drochans. Honorable Newport Drochans, are you happy now?
Mr. Chair, I think it was Ms. Jelly.
It was me, Chair.
Oh, sorry. Mama Jelly, are you fine?
No, good morning, Chair, and good morning, Mr. Dupree and the team. No, I'm fine, but when Chair, I was reading it, when I just want to find out who Mr. Dupree that is it how we have put it, is it clear according to the law? Because the law says when we do these laws, they must be clear to the court exactly what do we mean and all that. So is it simplified in a manner that representative, is it going to be clear? Because I'm thinking I'm not sure, Chair. Am I contradicting myself? Is it let me just put it like that, leave it there. But I'm saying, is it clear to the court? Because it seems as if for the court to understand this, they have to go to the dictionary and come out with that information. I'm not sure. I wanted just to get, if it's clear to the court, and the court will have to go and look for the dictionary and get those names and whatever. I'm fine, Chair.
Mr. Dupree, I think this bill, in fact, I think it was passed in 2002. Has there been a situation where it was applied? Is there a case law?
Not that I'm aware of, Mr. Chair, because we do not administer the Electronic Communications and Transactions Act, but I doubt whether it would have had or would have posed any problems in that regard. It is a standard operating procedure, if I may call it that, for if a term which there is doubt about the meaning and it's not defined, then the Interpretation Act provides guidance to the courts to then use the dictionary meaning of the term.
And I think generally all presiding officers have done interpretation of statutes.
That is correct, Mr. Chair.
Thank you very much. Can we proceed, Mamujel?
Yes, Chair.
Thank you very much.
Thank you, Mr. Chair. Then clause 3 of the bill as introduced, section 16.2 of the Constitution reflects race, ethnicity, gender, and religion. That is repeated in section 9.3 of the Constitution, and also in Papuda and in the bill itself. The additional grounds or characteristics are the same as in section 9.3 and in Papuda, except Papuda adds HIV or AIDS status. The bill as introduced added HIV status to the list of characteristics. Actually, it's the characteristics. Then nationality, migrant or refugee status, occupation and trade are the ones that were added, which we do not find in Papuda or in section 9.3 of the Constitution, and then also political affiliation or conviction and albinism. What is not included in the bill as introduced is pregnancy, marital status, conscience, and belief, which is contained in section 9.3 of the Constitution and also in Papuda. When we get to the hate speech clause, Mr. Chair, as introduced, a very similar picture, except, of course, for the bill as introduced, occupation or trade is excluded, and then also political affiliation or conviction. Once again, we do not find reference in the clause 4 list of pregnancy, marital status, conscience, or belief. Chair, I don't know whether there's any questions at this stage, but this was...
Yeah, I think that one, this one arose out of a question or engagement raised by Honorable Horn. Honorable Horn.
Yes, thank you, Chair, and good morning to all colleagues, as well as the department. Yes, Chair, as it is, we agreed last time around that I would also attempt to distill my views on this in writing in order for both colleagues and the department to be able to, let's say, in a more constructive way, also deal with my concerns. Unfortunately, I was a bit out of circulation until yesterday. I have taken up the task and I have made some headway, but unfortunately, it's not yet in writing. I am in a position to just verbally share one or two concerns, but with your permission, I think I would be able to ultimately finalize the document I'm working on by next week, Tuesday at least. So I stand to be guided by you, Chair, whether I must at this stage maybe just give an initial verbal input or whether you will indulge me a bit further.
I know you can make the verbal input and then we can take it from there.
Okay. Yes, Chair, in terms of the hate crimes concept and the criteria, what I have found is that internationally there's an understanding that ultimately for something to be deemed a hate crime, and this is specifically speaking to the characteristics, there must be three let's say hurdles that must be passed. The first is that not only the individual or individuals who's the direct victims of crime must be affected, but the designated group identified by the characteristics must by and large be affected, and ultimately then as a further requirement the reasonable part of society. So that would mean if we accept that that is the let's say the three requirements, then one would have to say that in respect of each of those, specifically those in my view that goes beyond the Constitution, once again reminding all of us that this is now criminalizing something that in terms of the Constitution up to now was dealt with mainly by civil remedies, then it would mean, Chair, that and I'm now back at that old argument of for us to consider this and for us to be satisfied that this stands any way of passing constitutional muster, we must be then informed that the department is convinced for reasons A, B, C, and D, that if an old person is attacked, or if property of an old person, for example, is then damaged, that ultimately for that to qualify as a hate crime, all old people should then experience some emotion because this crime was committed against an older person. And that emotional distress or reaction should also, if I understand the international benchmark correctly, as a consequence, even change their behavior, even if that means that they should think differently of themselves. So that's a fairly high mark and a benchmark, but I think also for good reason. And once again, Chair, that is because the internationally the roots of hate crime, of course, is to be found in a systemic pattern of behavior in which specific designated groups are then targeted by way of criminal activity. And that ultimately leads to the necessity to deal with something as a hate crime. Now, the difficulty we're sitting with, Chair, is that at this stage, this list, of course, is we now understand sort of where the list comes from. But once again, I must stress that in our view, the reality is that given the fact that we are criminalizing behavior, and we must now go around this with greater circumspection than when we passed legislation which ultimately aimed to root out discrimination. So that's the issue around hate crimes. And then, Chair, when it comes to hate speech, and to an extent even hate crimes, I want to maybe just also for the sake of time say that I do believe there is a recent constitutional court case which actually sets out both the way in which our courts would look towards matters, well, possible criminalization of hate speech, as well as hate crimes, and which ultimately, in terms of the limitation test, because remember, we said specifically in respect of hate speech, this is a limitation of the right to freedom of expression. And that is the case of the economic freedom fighters and Mr. Julius Malema against the department, the minister, the national director of prosecutions, and then there was some amici curiae, and it's the case 201 of 2019 in the Constitutional Court. And why I'm specifically raising this, Chair, is in this specific case, the court makes very, very express remarks around the manner in which the limitation test should be applied when freedom of expression is at issue through legislation. And I do believe we should be guided by the test set out in this case. Even when we make the laws, the court actually, in one or two of the passages, say that yes, this is the test the courts would apply, but it's ultimately the aim is then to see whether the legislature has overreached, and the legislature itself then should also be guided by this test when making laws. So in respect of the characteristics around hate speech, I also believe that if we read that case carefully, what also should happen is that for everything that goes beyond the Constitution, we should have a careful deliberation, and the department must come and show to us why there is a need for criminalization, specifically in respect of the very apt remarks the court make around proportionality. And the court also makes the very pertinent point, Chair, that it is not for government to just decide and then the duty is on whoever challenges it to come and prove that this is a disproportional limitation of rights. It is ultimately the duty of government to prove that it is not disproportional. And I strongly urge colleagues on the committee that we must be guided by that, those remarks of the court, and specifically that test, before we include any characteristics that goes beyond the Constitution. Once again, reminding all of us that this is, of course, also because we are now criminalizing. It is interesting that the court, even in going about this in a narrow manner, in that specific case, makes it very clear that it's not second guessing the need to criminalize, for example, incitement. So I must immediately say I'm not advocating for the use of this case as our yardstick or guiding us in terms of process to as the Deputy Minister has sort of suggested previously, just because we want this to be taken off the table. But I'm making a very strong plea, Chair, that for us to go about this in a rational manner and ultimately pass a law that would pass the limitation test and specifically the proportionality aspect around this, it's unfortunately not as simple as saying that this is where it has been sourced, specifically where it's sourced in legislation which do not constitute criminal offences. Thank you, Chair. That's as far as I can take it at the moment. I am prepared, if guided by you or asked by colleagues or the department, to then spend some time over the weekend and early next week to distill something in writing. Thank you.
No, thank you very much, Honorable Horn. I must say that we do understand the reasons why you could not furnish us with the written one. We suggest that you submit at least by Tuesday to both colleagues and to the department, so that they can be able to, we can be able to engage with it, and they can also do further research based on the case law that you have also outlined. We will await your written submission by Tuesday. Honorable Swart.
Thank you, Chair. Chair, I've got a connection problems on my side, but let's see how we can continue. And may I just thank you for your indulgence. As indicated previously, I was not able to attend due to the medium-term budget policy statement last week. But I do want to say that I appreciate what Mr. Horn has said. I think, and he's added the element applicable also to hate crimes. As you are aware, our main concern has related to the hate speech aspect, but I think when one looks at the wide range of characteristics applicable also to hate crimes, I think one does need to understand and have a full discussion around the inclusion of every item when it comes to the different elements. Mr. Dupree, great, he went through the different elements and he said these are inserted from there. These are some further discussions. One would like to also know who the discussions have been taking place with, but I presume that is part of the public submissions. The point that I want to make is when one takes the research document that the department provided, a lot of it was focused on hate crimes. But when the one aspect that related to the hate speech aspect highlights the fact that the issue of criminalization of hate speech is problematic. And I think that is something we've got to grapple with as this committee. Yes, the department, the minister, deputy minister are there to give guidance as well. But at the end of the day, we as parliament have to accept what we are legislating. We get inputs from the department, but we are the ones that pass the laws. And my concern is when we take the wide range of characteristics with the additional characteristics, when you couple that with the wide definition of harm, this results in a very wide definition of hate speech, which I believe goes beyond what the limitation clauses, particularly given the fact that this is now a criminalization. And when you're using examples from Papuda, which is civil remedies, this could well fail the test, the limitations test of Section 36. So I think I'm in agreement with Mr. Horn, and one looks forward to his input on these aspects. But I think that's the general issue that we are grappling with, is the wide range of characteristics, the wide definition of harm, resulting in a wide definition of hate speech, and maybe to a certain degree, the wide hate crimes, but that is a lesser degree in my view. The main focus for me is on the hate speech and the limitation that that has, and whether that would pass a constitutional test, given the issues related to section 16(2)(c) and read with the equality clause of section 9. And I think that is at the end of the day what we're grappling with. And I think we've got to really take time to go through each of these elements. Why are we adding each one of these characteristics way beyond? And is it justifiable just to say, because it was in Papuda, which is a civil remedy, does it pass a constitutional threshold when it comes to criminalization? We've got 3 years, 5 years criminal sentences possibly faced with, given what is internationally the fact that hate speech is problematic. Criminalization of hate speech is problematic when balanced with the rights to freedom of expression. So I think that is our broad input at this stage. We will be engaging on certain elements as we're going through, but thank you, Chair.
Thank you very much. Honorable Horn, can I ask you to just if you can submit by Monday, not Tuesday, so that at least on Tuesday we can engage with what you would have submitted, because if you submit on Tuesday, which means we can only engage with that on Wednesday, is it possible that we can do it on Monday? You can do it by Monday.
I will try my best, Chair. What I will also do is to alert you well enough in time if I'm not able to finalize by Monday, if that's in order.
Okay, thank you very much. Honorable Maseko Jela.
Thank you, Chairperson. Chair, before we close this matter of the characteristics for Monday or Tuesday, I wanted to check with the department. I think I agree with Honorable Horn when he says we should not look on this aspect of Papuda, but concentrate on the issue of the Constitution, because we want this to pass. It's fine, we see it's covered in Papuda, but on the issue of the Constitution, so that we don't find ourselves not in line with the Constitution at the end. But at least it helped us to see that those characteristics are also covered on Papuda. But my question, Chair, it is in terms of the approach, how the department is going towards finalization of this, those characteristics. There are some three or four characteristics that I was, when we go for the discussions, that I would like us to go deeper in understanding, maybe some of us getting understanding, some of us in terms of, like for example, the one of race, and the one of religion, and the one of the one of race and color, Chair. Those three ones, because I wanted to find out in terms of the format that we are going to follow, because if we are going to, for example, put it this way as a characteristics and not giving the meaning of that one or two of those, in order for us to understand why we reached the punishment that we would be coming up with, would be agreeing upon. It is going to me, Chair, lessen the punishment or increase the punishment, make it tough. So I was thinking that maybe also when we are going to discuss this, we must also discuss the issue of race in details, and religion in even if it's not in details, but get the definition, and also the issue of color. Because I'll tell you what, Chair, it's just that today we are not getting into those the discussion into details. I think it is the worry also that comes with the point that it has been deliberated on by Honorable Swart on the issue of religion. There are other issues on religions that when you go to the definition that one will want us to highlight, Chair. I want to leave it there because today we are just discussing we are being given just the presentation by the department. Would come back and discuss this issue. I'm not sure if maybe I understand very well in terms of the Chair. Have I confused you? Chair.
Thank you. No, I think let's hear also other people, then maybe if we can come back to it. Honorable Breitenbach.
Good morning, Chair. Thank you, and good morning to everybody. I agree with the inputs of my colleagues, particularly those of Mr. Horn. And I want to emphasize, Mr. Chair, that we're going to have to, what we're doing here, really, in essence, is we're trying to legislate morality, which is not a terribly successful recipe in the general scheme of things. It's what we're trying to address here is a different issue, and criminalizing it is, in my view, not the most effective way of dealing with it. However, we have this piece of legislation, we must deal with it. I hold the view you cannot legislate morality. Having said that, we need to legislate for very carefully when we're legislating criminal offences for what are essentially up to now have been civil offences, and we need to interrogate very carefully this very long list of categories that appear to, with respect, to have been plucked from a variety of sources, and that do not fit into the limitations clause. I agree that they are going to cause us to fall foul of the limitations clause to a large extent, and many of them are repetitious, many of them are controversial, and this legislation is a long way from being finalized. We're going to have to interrogate each and every category very carefully and satisfy ourselves that it's the responsible thing to do, to include them. Because we're not legislating for ourselves or for a pretty piece of legislation. We're legislating for the citizens of this country. And we need to take that very carefully into account. We must always legislate for the worst possible case scenario, not the best. I just want to emphasize that which Mr. Horn has already said, in fact, and that we really need to be very careful when we interrogate these categories, and we're a long way off from finishing that. Thank you.
Thank you very much. Deputy Minister, would you want to come in now, or we first allow Mr. Dupree to deal with the technical aspects and then you can come later, or you want to come in now? I'll be guided by you.
Chair, no, just I've got a time problem as I'd indicated. I'd need to leave by 10:15 for another meeting and then a dentist's appointment. So I don't know how long. Look, what I did want to say is maybe let me just say the points. I see the bill is being flighted. Just in terms of the responses, I think that, remember, this is two parts: hate crime and hate speech. Hate crime is basically existing crimes, which, because of the motive, then becomes that crime as a hate crime. So it's not really particularly criminalizing, because they have to be already crimes. They already have to be crimes. It is an issue of exacerbating the crime, and then there are consequences of it being a hate crime. It has to be recorded, the victim impact statement, etc. And I think in the hearings, there wasn't too much input on this point. The characteristics do relate to hate crimes. What are hate crimes? What are the characteristics for hate crimes? Let's see Mr. Horn's input. Just the case he's speaking about is the Writers' Assembly case, EFF versus the Minister of Justice. So it was more specifically, although the court did deal with the issue of expression, and it is an earlier case to Kwelane. But the characteristics, unfortunately, Mr. Or whoever's taken the list that was up there before, each of the points, some were in the Constitution, some such as pregnancy, marital status are in the Constitution and Papuda, but were not included in the bill because the view was that people don't get attacked because they're pregnant. I mean, they're part of a group of pregnant people. You have had attacks on pregnant women because they're pregnant, but it's been specific to that woman. The girlfriend, I mean, the ex-girlfriend attacking her because she's jealous of the fact that the new girlfriend is now pregnant with her ex-boyfriend. But that's not part of it as a group. So I think, yes, I'd agree members need to interrogate each one, but these are aggravating factors effectively. HIV or AIDS wasn't in the Constitution. I don't know whether it was, well, it was around when the Constitution was being finalized, but maybe it wasn't at that time seen as serious. Albinism, which is something that keeps coming up in international treaties, I think that's which is not in the Constitution or in Papuda, I think is straightforward. Albinos run the risk. There are hate crimes against people on the basis of their having albinism, and those crimes need to be made more serious, which is effectively what the hate crimes aspect is doing. On the issue of hate speech, that I would agree is criminalizing, and that we've got to be particularly careful in terms of the limitation clause. And we've got to look at the purpose of the limitation, the nature and extent, the relationship between the limitation and its purpose, and is there a less restrictive means? There's some of the factors in section 36. Now, in Kwelane, the court had quoted the United Nations Rebut Plan of Action, saying our approach accords with that, which is criminal sanctions related to unlawful form of expression should be seen as last resort measures to be applied only in strictly justifiable situations. So that's what they had quoted as authority in Kwelane. I disagree with Honorable Breitenbach. I don't think it's a morality issue. It's an issue of harm caused to particular people. And primary is race, where I don't think it's a moral issue that a Black person gets offended, gets harmed by the fact that what has been said about them, not as an individual, but as part of a group, is offensive. I don't think that's a moral issue. But we have, and I think Mr. I'm not sure who's running the control. You would see that we have. Sorry, go back to harm. We have made proposals on which Mr. Duprier will come into the definition of harm. Harm relates only to hate speech. So if honourable members can please have a look at that, those additions or changes to the definition of harm, because for it to be hate speech, it has to cause harm, and there's various other things with harm. And then we'd also made proposals on the grounds, which are the factor, and if you can go to the grounds now, in terms of under that proposal, a more limited set of grounds which would qualify as hate speech, trying to pick those areas. I mean, the problem Mr. Horn was asking earlier about what are the statistics of the cases. Unfortunately, the NPA don't keep that. So we can't say there were so many cases involving murders of people with albinism or so on. But those are the sort of grounds that we are now proposing as the most serious ones that should be included as issues relating to or that would become hate speech. The issue of some of them, like for example, political affiliation or conviction can lead to you getting killed in a hate crime, but we've excluded them from the grounds on the basis that it would possibly too much infringe on freedom of speech and curtail debate. The same with occupational trade. Hawkers, bus drivers, sex workers do get attacked because of what they're doing, not because of the individual who they are. However, if we have that as a ground for hate speech, it may also curtail criticism of politicians, of lawyers, etc. So that's why that's not included. So, Chair, as I said, unfortunately, I can't stay too much longer, but I just wanted to make the point. I would appeal to Mr. Horn that please, I know you've been through difficulties, and my condolences on the passing of your father. But if you can have it by Monday, then at least one can move the process forward. But can members please look at particularly the changes I think that Mr. Dupree will go through now on harm and grounds, which are particularly the requirements for hate speech, and then just to dispute that the hate crimes aspect is in fact criminalizing something new. A hate crime is an existing crime which is made a hate crime and exacerbated by the motive that it was committed for. But we do need to interrogate those lists. I would agree with that. Thanks, Chair. Thanks, members.
Thank you very much, Honorable Deputy Minister. I will still need the issue of characteristics versus the grounds. For me, I think they sound to be very much similar. And most of the I'll say categories are the similar, except that ground has excluded some. As to what would you say are the characteristics in terms of definition versus the grounds?
Chair, look, the characteristics would be the full list for hate crimes. That you do commit this crime because you don't like the age, the birth issues, culture issues relating to the victim. What we've done with the grounds is then to take the characteristics list and then, as you say, exclude. And those exclusions basically, particularly with the proposal that we're making today, before there were only 2 exclusions, is to say, no, let's actually, we propose that we increase the number of exclusions and keep the grounds to, in terms of the limitation clause, issues that we can clearly justify that the harm caused through hate speech is so serious that society needs to be protected from it. And I think Mr. Dupree will go through the issues, but they are in particular issues that cause extreme harm, that can cause people to die. So HIV and H status wasn't in the Constitution, but people have been killed when they've come out and said, I'm HIV positive. That would be a hate crime. Any attack on people because of their HIV status or their AIDS status from a speech point of view can cause severe harm. And that's why that, for example, is there. So I don't know if that answers you, but the grounds are basically the characteristics, but have taken from the characteristics. You won't find a ground that's not in the characteristics, but we are saying we feel those are the more serious issues, that a curtailment of a limitation of free speech in terms of the limitation clause would be justified, reasonable and justifiable. Thanks, Chair.
Thank you very much, Deputy Minister. I think at any time that you would want to leave, I think you will be released.
Chair, sorry, may I engage with the Deputy Minister before he leaves, please?
Yes, Honorable Breitenbach.
Thank you. I agree with the Minister's interpretation of moral as he sets it out. I'm not approaching it from that point of view. My difficulty is that the immorality lies therein that that people initiate these actions in the first place. I have no quibble with people being offended by the result of hate speech or hate crimes. I'm saying the morality issue is the other way around. The person committing them, that's what we're trying to legislate, and that is, in my view, a morality issue. But notwithstanding that, the examples that the Minister has now quoted are all already crimes. And if you kill somebody, if you murder somebody because they have HIV, that's murder. It's already a crime. It's a serious offense. It carries a minimum sentence. And if you can prove, as you would have to do for this crime, that it was motivated by particular discriminatory views with regards to somebody with HIV, that would be a serious aggravating circumstance, which would attract serious consequences. So, and that is applicable to many of the categories in this bill. They're already crimes, they're already serious crimes, and they already attract serious sentences. And what we're talking about here are aggravating circumstances, which, when applied in a criminal trial, will have the effect of an even more serious sentence. So it would be taken care of there. But that's something that we can debate at the next sitting. Thank you, Mr. Chair.
Thank you very much, Honorable Breitenbach. Honorable Horn, are you still on the same issue?
Yes, Chair. I also wanted to engage the Deputy Minister if he still has a minute or two available. I think the Honorable Breitenbach has covered the first issue largely, but maybe I must just add this. One of the things we obviously must also wrestle with is whether we want hate crimes to be a crime in itself, or whether it's ultimately aggravating in nature. So the difficulty is at this stage, of course, we sit with a situation that it would be a separate crime. So Mr. Dupree has gone to some length last time around to say this is ultimately how the crime would be reported on in terms of the criminal record of somebody who's found guilty. But I agree with both the Deputy Minister and the Honourable Breitenbach that what we should also consider is to see whether this ultimately should not act only as penalty enhancement factors. The second aspect I wanted to just engage the Deputy Minister on is that, and that's around hate speech. Just to touch base with him whether he has, through his input now, advocated for a slight change in the wording to include something around serious harm. That's a term he's now repeatedly used in his input to the committee, but currently it's not necessarily part of the requirements. yes, if one looks there, but the Deputy Minister is now in his responses or his input. I don't know whether it was maybe just to put emphasis on other matters, but I mean, it would make a vast difference. Maybe also referring back to the input of the Honourable Swart, if the benchmark ultimately is serious harm rather than just harm as currently defined there. Thank you, Chair.
Thank you very much. Honorable Jelle. If we are expecting responses, I think we must also bear in mind that the Deputy Minister has to leave. If our inputs can, the ones that we require responses from him, if they can be as brief as possible.
Oh no, Chair. I just wanted to just that he will have to give us he has omitted some, like he says, from the characteristics to the grounds. Chair, on section on issues of equality, section 9(3), they are including, Chairperson, on the grounds they are including the issue of culture. There's culture there. I'm looking at this one. There's a culture also, Chairperson. There is also color also here. But when you check from the grounds, they have omitted that. I think it goes back to what you said earlier in terms of the characteristics and the grounds, because if the grounds are going to be, they are the ones that carry a weight, Chairperson. The Constitution cover even the ones that they omitted from the above characteristics. I don't know if maybe the Minister can also comment on that one. Why did they omit those ones also? Thank you, Chair.
Thank you very much. Honorable Swart.
Chair, did the Minister say 10:15? I think that's not 10 o'clock, but just very quickly, I think the discussion around the hate crimes aspect is interesting, although it hasn't been a big focus, just on the issue of the creation of a separate crime as opposed to the existing crime with aggravating circumstances. Does the Minister foresee that you would have a separate crime plus aggravating circumstances possibly? So that's just on that side issue. I don't have too many problems, but this is an interesting debate on the hate crimes aspect. And when it comes to the hate speech aspect, I think it's important to have some lift the bar as one can when it comes to harm, when it comes to those broad definitions, we'll look at the characteristics. But just to give an example, I already have got a slight problem with using the papuda, which is a civil remedy. But even when you look at the Constitutional Court's definition of harmful based on the civil papuda, it has a higher bar as opposed to the bill, where the bill says harm means any emotional, psychological, etc. The Constitutional Court says harmful can be understood as deep emotional, psychological. So there's already a qualification there. And so something along those lines, that we need some qualification, serious, deep, those type of qualifications when it comes to the controversial hate speech element. Thank you, Chair.
Thank you very much. Deputy Minister.
Thanks, Chair. I hope you can see me okay. I can't see myself, but anyway. Okay. Basically, hate crime is an existing crime which becomes a hate crime because of its motive. So the idea is listed in the bill is you commit murder as a hate crime because the person you murdered, you didn't like the group that they belonged to. And the consequences of that, Honorable Breitenbach has before raised the issue of why do we need this? It's aggravating circumstances. would be that internationally we are seeing a growing trend in hate crimes, crimes committed not because of the subjective dislike of the person, but because of the dislike of the group the person belongs to. And one, that those crimes should be recorded. But as I said, it will be rape as a hate crime, murder as a hate crime, arson as a hate crime, etc., etc. If you're able to prove the B part of the crime. And then also there's issues relating to victim impact and statements being basically compulsory now. If they cannot be given, the court, the prosecutor must give reasons to the court why not. There's provisions relating to training, sentencing, etc. So it's and internationally, I mean, countries are coming more and more with hate crime legislation as it becomes more of a problem. On the hate speech issue, the problem may be you say something negative about a particular group of migrants. You've got to cause, in terms of if those migrants get attacked, or refugees, if they get attacked, you've got to prove basically a causal link. Whereas what the hate speech provision is doing is making it a crime on its own to say these things. So I just sort of want to point that out. On the issue of race, it's not yet necessarily going to be at this stage promoting violence against a race. But it's going to cause extreme unhappiness from affected people and damage the feelings of that race that the person who commits the crime is coming from, feelings from the race that has been insulted to that other race. So, that would be the motivation for separate hate speech as a separate crime. But as I said, I think we with the characteristics, we wouldn't have seen it so much as limiting rights, and therefore that list is wider. But the hate speech issue very much is, and we need to be able to justify that in terms of the limitation clause. And those are the factors that we brought in. We can debate the issue of color, which the proposal from the last meeting was skin color. Basically, that crimes can be often in some cultures, it's seen as better to be lighter and worse to be darker. And if there are offenses committed against a person because they're particularly of a darker skin color, that would be covered as a potential hate crime. But with hate speech, we thought, okay, race is more inclusive than just color. Well, race-specific color can fit within race, but that's why we excluded that. But that can be debated. On the issue of the definition of harm, which is the real key to the question of what is hate speech. What we've put in is objectively and substantially undermining the human dignity of the targeted individual group. So harm as it's on its own becomes that. We can look at qualifying the emotional, psychological, social, cultural, or economic detriment suffered. So that's something that can be looked at. But that's where we think the key. We would want to urge that the key debates is the definition of harm and the list of characteristics. Thanks, Chair.
Thank you very much, Deputy Minister. Members, as I think you can hear the serious thunderstorm this side. Can we, as the Deputy Minister is leaving, maybe we have a 15 minutes break. So that I think this thing can pass. Will that be in order?
Agreed, Chair.
Sure, thank you. I'm back at 30 past.
Recording stopped.
because I'm quite sure that the main focus of the discussion will be around the definition of harm, and then of course the characteristics and grounds. So I would like to maybe just get the opportunity to indicate to the committee under objects clause 2, no proposed amendments. Now the offence of hate crime as introduced, we've already taken the committee through that at the previous meeting, but we have the proposal for a redraft of subclause 1 to maybe make it clearer what is precisely meant with what a hate crime is. And then with regard to clause 2, and I think maybe I could repeat myself here for the advantage of some of the members that were not present at the previous meeting. Subclause 2 at this stage, or as introduced, provides that any person who commits a hate crime is guilty of an offence and liable on conviction to a sentence as contemplated in section 6.1. The concern arose among us, or the team members, that if you look at the rest of the bill, the SAPs and the NDPP or the NPA, they are supposed to keep certain statistics and record certain data. We were concerned that if subclause 2 stands as it is, the criminal record of the convicted person will only reflect a reference to a hate crime. But that's only half of the story, because one person may, for example, be sentenced to jail for 10 years and the other person for 25 years, and you don't really know, the criminal record does not really reflect what the baseline or the underlying offence was that gave rise to the conviction of a hate crime. So the proposal from the department side is that we split subclause 2 into 2 paragraphs. The first paragraph is then merely or mainly a repetition of what the introduced subclause 2 looks like. And then in paragraph B, in an attempt to make it clear what should be recorded, is to say that a criminal record of a person who has been convicted of an offence must explicitly record the underlying offence as a hate crime. So if I'm found guilty of a hate crime but I committed murder, then the criminal record of my criminal record must then reflect murder as a hate crime. Subclause 3, nothing much to say there, Mr. Chair. And then maybe just a few technical amendments in the introduced sub 1. We've already gone through them with the committee. And then we have the proposal with regard to sub 2. Those are the exclusions, to also provide a redraft to the committee to make it clear that all 4 paragraphs must be done in good faith in the engagement then of any bona fide, for example, artistic creativity. And then the rider is that such artistic creativity does not advocate hatred that constitutes incitement to cause harm based on one or more of the grounds as then defined in clause 1. Mr. Chair, will you please just allow me a minute? I just need to get some water. I can feel my voice is going again. Sorry, Chair.
Okay, sure.
Sorry, Mr. Chair, I'm back.
Okay, thank you. You can proceed.
Thank you, Chair. So with regard to the victim impact statement, the deputy also alluded to that this morning. The proposal that we have discussed with the committee at the previous meeting is to clarify that where it is not possible for a prosecutor to obtain a victim impact statement, that prosecutor must provide the court with reasons for the absence of such a statement. With regard to penalties or orders, if I remember correctly, it's only the correction of a spelling mistake in the bill that's introduced. And then to clarify. And then when it comes to subclause 3, which deals with the hate speech element of the bill, the proposal from the department side is that we should not draw a distinction between a first and subsequent convictions, and that the maximum for hate speech offense should then be a fine or 8 years imprisonment, or then both the fine and the imprisonment. With regard to national instructions and directives, there's nothing new there. And the committee members, so this is exactly the same as previous versions that the committee members received. Reporting on the implementation of the Act. Once again, just a technical correction. In 9, just the inclusion of the commission. With regard to regulations, nothing new, Mr. Chair, as well as the last 2 clauses. I would like to maybe just go on where I left off last time. Mainly technical amendments to the schedule to the bill, and mainly, of course, to correct the reference to the Act as a 22 Act and not a 18 Act. The one aspect that I would like to highlight to you, Mr. Chair, and we concluded at this point at item 2 at the previous meeting. Section 20, Chapter 26 of the Criminal Procedure Act deals with competent verdicts, and Section 270 is the last provision in that chapter. Now, we have 2 technical concerns. If we insert a Section 270 capital A after the existing Section 270, then the index to the Criminal Procedure Act will also have to be amended. But we are of the view that it's not necessary to do that. For us, the solution is quite straightforward, and I'll explain to the committee why. Section 270 is a catch the rest provision, not a catch all provision. So what we can do is, and that would be the proposal from the department side, is to insert after Section 269 capital A, to insert this section as Section 269 capital B. Then it will not be necessary to amend the index. And the other advantage that we have there, and that's possibly only a technical issue from my side, is that since Section 270 is a catch the rest provision, it would be more appropriate in any event to insert a 269B before 270. And with your permission, Mr. Chair, I would just like to quickly, it's a very short provision, but Section 270 deals with offences not specified in Chapter 26. And it reads, if the evidence on a charge for any offence not referred to in the preceding sections of this chapter, does not prove the commission of the offence so charged, but proves the commission of an offence which by reason of the essential elements of that offence is included in the offence so charged. The accused may be found guilty of the offence so proved. Apologies, Chair. So
please take a deep breath and drink some water. We can give you 2 minutes.
I'm fine, thank you, Chair. I don't know whether it's really necessary now. We will once again trawl through this proposed amendments just to make sure that everything is in order. But I think, and then with your permission, Mr. Chair, I'll go back to the definitions then of characteristics then and grounds. I may mention to the committee the A list that we are going to prepare and the B list, of course. We've only inserted characteristics after hate speech and grounds just for ease of reference, but they are not ordered alphabetically, so they will be ordered alphabetically then in the A list and especially then importantly the B list. So when we get to the definition of harm, Mr. Chair, the original insertion in the committee's working documents was the reference to cultural, which was a proposal by one of the interested parties. And then there was also the concern expressed that the current definition is circular to the extent that we define harm with reference to harm. Now, it might then be more appropriate than rather to refer to detriment, and then in order to ensure that an objective test is applied by the courts, reference to objectively and then substantially undermines the human dignity of the targeted group or individual. These insertions were made as a result of submissions that were made to the committee by interested parties, especially then with reference to the Kwalani judgment. I don't know whether I should pause here, Mr. Chair.
I think so, because it will read as harm means any emotional, psychological, physical, or social, cultural, or economic detriment. I think there was an issue raised by Honorable Swart with regard to any emotional, that we might need to include a higher test. He made reference to deep emotional and psychological. Yes, deep means means deep emotional, psychological, physical, social, cultural, or economic detriment. I think maybe that might be one area that we might want to debate a bit. Honorable Swart.
Thank you, Chair. Yes, that follows from the Kwalani judgment, where there is reference to harmful being understood as deep emotional, psychological harm. It just raises it, and I think just add that as an option, as opposed to any, to insert the word deep. Can we just put that in as an option, please?
Yes. Any deep emotional, yes. Are you done, Honorable Swart, on this issue of harm?
For the time being, just on this issue, thank you, Chair. Thank you.
Thank you very much, Honorable Jale.
No, I'm fine, Chair. I was worried about that one also. I wanted to emphasize what Mr. Swart said, Honorable Swart said.
Thank you very much. You will look at that, Mr. Dupree. No, which means we are done so far with the definition of harm. Can we move to the next one? That is characteristics.
That is correct, Chair. Thank you. Yes, the characteristics then, you will see that reference to color in paragraph D has now been deleted, but in view of the fact that we also use the list or list the different characteristics alphabetically, skin color should then be included at the bottom of the list. And then the whole issue of marital status and pregnancy was discussed and highlighted by the Deputy Minister. Although it is a ground contained in section 9.3 of the Constitution and also in Papuda, there's a strong feeling that this marital status and pregnancy should not form part of the grounds for a hate crime or characteristics for a hate crime. Mr. Chair, I'll leave it at that.
If I understood the members of the committee, they will correct me if I'm wrong. Maybe there might be a need for a document like the one you prepared for the purpose of this meeting, to have the ground and the characteristics linked to or explained deeper in terms of the limitation clause. I think it's the limitation clause that is one area, and the issue of proportionality.
That's my understanding as well, Mr. Chair, and I think that is a discussion that will, I think, most probably then stand over to the next meeting of the committee.
Yes.
After we have received the written input.
Yes.
Mr. Chair, I'm terribly sorry to interrupt. Can I ask that they allow Mr. Engelbrecht back in? He's off the platform and he can't get back on.
Oh, okay. Please do so, Committee Secretary.
Thank you. Thank you. I've been added. Thanks.
Thank you very much and welcome back, Mr. Honorable Engelbrecht. Let's proceed. Honorable Swart, is that a new hand or an old hand?
Oh, no, taken down. Thank you.
Chair.
Okay. Honorable Chair.
I still want, yes, I did hear the explanation of the DM about the removal of this one of pregnancy and the marital status. But I still want to get more explanation. Maybe when we come and discuss again, we will have to find out more, because when I looked at the Constitution, what is that? Is it section 16? But I said they are, or this one, they're not listed. Pregnancy is listed, Chair, if I'm not mistaken, when I was reading here. Yes, it is listed, Chair, on the issue of equality. So I wanted to find out from Mr. Dupree, the motivation on this one. Maybe I missed that one. Why remove that one? Thank you, Chair.
Thank you very much. I think I think our understanding with Mr. Dupree is that all of them are going to be explained and motivated in terms of the two tests, that is proportionality and the issue of the limitation clause, so that we can have a fuller discussion on each and one of them, whether they should be included or not excluded, both on the basis of those two tests and any other test that members would want to motivate or demotivate based on that. So,
okay, Chair, thank you.
Yes, our understanding is that the constitutionality of the bill could be attacked based on the definitions and characteristics and grounds. I think that will be the main the main text. So we would need to have a fuller and a deeper discussions on each and every characteristics, ground, or definition.
No, I'm happy, Chair. Thank you.
Thank you very much. Mr. Dupree, you can take down your hand, Honorable Jelly, so that when you raise it, I will know it's a new hand. Thank you very much.
So, yes, Mr. Chair, you will recall that the clause 4 as introduced includes all the characteristics except then for the two grounds, occupational trade and then political affiliation or conviction. But the department would like to propose then to the committee that possibly an attempt was made by the department to try and cut the list, if I may call it that, by considering the most serious grounds to be included under the ambit of hate speech. There's not much more that I can say at this stage, Chair.
I think what we have just said, I think it will take also care of that, because I think things as they stand now, the issue between characteristics and the grounds is cutting some, and I think it's a bit arbitrary. I think once we have been able to motivate, then we can be able to have a test as to what would constitute grounds and what will be lesser that will go into the characteristics.
Yes, Chair. I think I agree with you, Chair.
Mr. Chair, I don't know whether my DDG, Ms. Pillay, and my colleague, Ms. Botha, would like to say something at this stage, possibly generally about the bill, or possibly then the three definitions. With your permission, Mr. Chair, I would just like to get an indication from my colleagues whether they would like to add something at this, one could possibly say, preliminary stage pending the submission that will be made.
The DDG is present. Good morning, Ms. Pillay and Ms. Botha. You are welcome to talk, to speak.
Thank you, Chairperson. I have nothing to add at this stage, but as we go on, if I have, I will raise my hand later. Thank you.
Thank you very much, DDG. Ms. Botha.
Thank you, Chair. I also have nothing to add at this stage, but if I need to, I, like my DDG, will raise my hand later. And I agree with Mr. Dupree that when we receive the note, it will be much easier, I think, for us to address some of these questions then in writing. And then we can dig into some of the issues that you've raised, Chair. Thank you.
Thank you very much. Honorable Swart.
No, Chair, I think I appreciate the direction that we're heading into, but as we consider, and I appreciate the department's going to prepare a note, but clearly your starting point is your section 16(2)(c). Those 4 points: race, ethnicity, gender, or religion. Given the fact that we are criminalizing a very controversial aspect of hate speech, and one could argue, and we would argue, that one should, in fact, you should limit yourself to those 4 aspects. Even the question of section 9, which is your equality clause, doesn't address itself to hate speech. But obviously one can consider those additional items, but you would need to justify why you add in equality provisions under hate speech. And then, of course, one has to justify the PAPUDA aspects, because that's a civil remedy when you are considering limitations, the clause, and the least restrictive methods. I think it is critical for us to understand that there's already criminal remedies in terms of our common law, and that when you are considering the test of constitutionality, one has to limit your grounds as much as possible. And in fact, stick to these aspects of section 16(2)(c). But I think that would be open. One would have to open that for debate. But that would be one's viewpoint, to try to limit it to those few grounds. And so I look forward to the discussions around all the other characteristics and that. But I do think as you are adding, that you are open yourself to broader constitutional challenge, given the fact that you're dealing with very controversial hate speech issue, which the research document has said internationally is very problematic. Secondly, that there is already the criminal common law sanctions. But Chair, that's just an input. I'm just re-emphasizing what I've already said. Thank you so much.
Thank you very much, Honorable Swart. Mr. Dupree.
Mr. Chair, yes, thank you. I'm reaching actually a point where I would like to, or maybe just go back and prepare a response to the document that will be submitted to the committee. However, I would like to mention, Mr. Chair, it's extremely important, and we have answered some of the criticism when we received those in the comments by the interested parties. We have from the beginning indicated that there's two aspects. Hate speech is a very serious offense, and it doesn't prevent the legislature from supplementing the common law, because generally speaking, there is still a bit doubt whether criminal injury is only committed against an individual or a group. There was reference to one court case where it was indicated now that criminal injury do apply to groups. But in essence, the legislature is now going to give that offense that will be created a name, and it's going to be hate speech, and that is then generally or broad overview of the gist behind the proposed hate speech provision. Thank you, Chair.
Thank you very much. I think we are done with the bill for today.
Chair, before you, sorry for the interruption. I just want to hear the conclusion, because from the input of Honorable Swart, it is like they must limit themselves into those numbers that he mentioned on the issue of grounds and characteristics. I'm not sure if are we still saying, Chair, they must go for almost everything that so that we can get more clarity. Are we going for those few ones, or are we also including others on top?
No, the document is going to expand and motivate on each characteristics and ground, so that based on what the motivation is, we can decide whether we exclude or we include.
Thank you, Chair. Thank you.
Thank you very much. I think, honorable members, I think for today we have come to the end of the bill. We will give time to Honorable, in fact, to Mr. Swart, not Mr. Swart, to Mr. Dupree, to go and work on the document, and Honorable Horn and any other member who would want to make further submissions to the department and to ourselves, they will circulate their views, so that on Tuesday we can further deliberate on this bill, and then we will see how far our discussion takes us on Tuesday. And then we would move towards what is this thing, list A and list B as we move. But we are not rushing, but we will be guided by the discussions as we deliberate. Honorable Swart.
No, Chair, I'm covered. I would like to make some more submissions on some of the exemptions, just to propose some wordings, but I will also start working on a document. I appreciate the fact that we're not rushing, but that there are opportunities for additional submissions. Thank you, Chair.
Thank you very much. Mr. Dupree, thank you very much and to Ms. Calum and Ms. Botha, thank you very much for the work done. I think I think you have done a very good job in terms of guiding us. You know that there will be a lot of to and froms as we do the bill, but we are very happy with what you have presented. And we know that it does not come as easy as we think it does, but there's a lot of hard work and that is put in by the department. Thank you very much for that. You are excused.
Thank you, Mr. Chair, and have a nice day.
Thank you very much.
Committee members. Thank you, Chair. Bye-bye.
Thank you, Chair.
Thank you very much.
Thank you, Chair.
Thank you very much. Let's, honorable members, we have asked, in fact, the report of the oversight, the justice part, as members would know that we have already adopted the report on the correctional services side, the oversight report. So can we deal with the report of the justice side of the oversight, and welcome the chair of the section 194 who has joined us. Is committee secretary.
As Mr. Janki finally recused himself.
No, I think he will respond in the section 194 with respect to those issues. The report was circulated. It's going to be taken as read. A report of the Portfolio Committee of Justice and Correctional Services. Can you reduce the font? I can't see everything. Let me close here. Yeah. Report of the Portfolio Committee of Justice and Correctional Services on oversight visits to court and justice services points in the Eastern Cape, Free State, Gauteng, KwaZulu-Natal, Limpopo, Mpumalanga, and the Western Cape, dated 4th November 2022. Are there any corrections on page 1? We will rely a lot on the leaders of the delegations and members who are part of either of the streams to assist us to recall some of the issues. Are there any corrections on page 1?
Chairperson.
Ma'am Jale.
Thank you. I just want us to go to 1.2 on that in the introduction.
1.2.
Yes, 1.2 introduction. It reads for it to be able to visit more widely in the time available in the committee divided. I think there was something I wanted to add. The committee divided members. I think there's something wrong there. I'm not sure. Yeah, there's something wrong. I thought that maybe if they can say divided the members, the committee members into 2 groups of delegations, something like that.
Mr. Stone. Because you can even say
yes.
The committee divided itself into 2 delegations. So you choose the appropriate one.
Yes, you could say the committee divided itself into 2 delegations. We could say the members divided
yes.
into 2 delegations. So it's just depends on which ones you prefer.
Yeah.
Well, members were divided into two delegations.
Yes, I
Yes.
want just correct or
Yeah.
whichever, but at least.
Yes.
Okay. I'm just going to highlight that. Sorry, Chair, I just want to say that I have just had a glimpse through. There is a numbering issue in one place, and there's some highlighted spots. I think those were notes to myself, and they sort of, the glitch got stuck in there still, but we will take care of those. And of course, the members can raise questions when they get there.
No problem. Page 1, page 2. Yes, page 2. Page 3. Page 4. Just sorry, just something that I think we is not part of the report, but I think members who are staying in the Western Cape, especially Cape Town, there are still serious problems that are reported in the Western Cape, the Master's Office, that needs to be addressed. And well, I received a call about the Master's Office, but the other one is with respect to Home Affairs, which we would refer it to the chair of the Home Affairs Portfolio Committee. The issue relating to long waiting lines. It's some of the things that I think those members who are in the Western Cape should keep track to those issues. The Master's Office is still a big challenge. And let's proceed.
Honorable Nihodruchen has a hand up, Chair.
Honorable Nihodruchen.
Yes, Chair. Thank you. The Secretariat, if I could ask them to go back to 1.7 and the last line. It was in yellow and there was a question mark. So I just wanted to check what is supposed to be there. Paragraph and is highlighted in yellow. What is supposed to be corrected there or added there?
Chair, yes, that is what I was referring to. That paragraph needs to be, it needs to reference to the very last sort of paragraph in the report. But the numbering has changed a bit. And when I went there, I can see that there's something's happened in the translation of sending it all. So I just need to check, I need to correct the numbering and then check the paragraph number. And that will be filled in.
Okay. Thank you. Let's go to page 4. This issue of maybe matters arising, this issue of the CRT machines, at some point I think we need to get an update as to what is the position now, because it's one issue that is very, very serious that we picked up and we are sure that it's being attended to. It will be important that people whom we have assigned to go to provinces to make follow-up visits to specifically also look at this issue of the CRT machines. Page 5. Page 6.
On page 6, there's just a
We'll
spelling
read them.
error. Okay? The third bullet point from the bottom in paragraph 222. Legally qualified staff are needed to deal with queue management and the, should be, I think, the digitization of records.
Good. Oh, spelling mistake. Okay, okay. Thank you very much. Let's proceed. Page 6, page 7. Page 8. Page 9. Page 10. Page 11. So page 10, it's that pink thing is, it's part of your notes, Ms. Silkstone. Is that one, is it part of your notes?
Yes.
Okay. Page 11. Page 12. Page 12. Page 13. Page 14. Page 15. Page 16. Page 17. Page 18. Page 19. Page 20. Page 21. Page 22. Ms. Silkstone, you take care of that. Page 22, let's go down. Page 23. Page 24.
Honorable Newt-Ruchen has a hand raised, Chair.
Okay, Honorable Newt-Ruchen.
Apologies, Chair. On page 23,
Yes.
5.2.9.
Okay.
The sentence, the first sentence that it said create an enormous what? What is enormous?
Chair, it will be like problem or challenge. I think challenge is probably the best.
Yes. And then the issue of deputy public protectors, I think it's deputy directors of public prosecution.
Yeah, sorry. You can see how my mind works. Public, I'll sort it out, don't worry. Public prosecutions here, or Banani.
But members, on this issue of deputy directors of public prosecutions, I think we need to get the minister and the NDPP to generally tell us when is this thing going to come to an end? Because I think for the past 10 years, we have been getting some form of progress report that does not give an end to the issue. I mean, quite a number. I mean, I know in the case of Senzo Meiwa, the state is led by a deputy director of public prosecution. So they do prosecutions, they do management, they give leadership and training to their senior, to their juniors under them. So it cannot be acceptable that those juniors will earn more than them. No organization will run like that. It's just unjustifiable. So we can't have a situation that is going to linger for many years, and in fact it outlasts many terms, that is parliamentary terms, and there's no there's no end to that particular problem. It can't work like that. So I think it's important that both of them, they don't come to tell us processes. They must just come and tell us when is it being solved. Because it just does not, it just defies logic.
True, Chair, supported.
Yeah, I think it's part of what we should include in our next year's program. And if Treasury needs to be, maybe we can start throwing the salvo in our BRRR report that they must see to it that issue is solved. Because immediately we are going to have people who deserve to be deputy directors of public prosecutions do not want to apply because there is no incentive for them to apply. We are creating other problems for the organization. So I will find with page 23.
Chair, if I can comment on this one.
Yes.
It seems as if it's not only the problem in our department. It also cut across, Chair. Even in other, I remember when I was still in the municipality, they changed the whole thing. You find that people who are coming now, Chair, there's a problem. The salary does not match the position, and you find the very same situation, and people end up not working, and lots of problems, Chair. on this one. I think it has to be resolved, but I'm not sure how, because it's not something that is only here. It's experienced by us. It cuts across, Chair. Thank you.
Well, thank you very much. Let's try and do what we can do ourselves. Let's solve where we are, and hopefully others will do the same where they are. Let's solve this issue of because it has even been to court, this issue of deputy directors of public prosecution and chief prosecutors. But I think your insights as to what are the problems in other areas would help us to understand the bigger problem, but it has to be solved because it's a problem.
True, Chair.
Thank you very much. Let's proceed. (24). (24), 25, 26, 26, 27, 27, 28.
Honorable Newtruchen has her hand up, Chair.
Honorable Newtruchen.
Thank you, Chair. On page 27, the last paragraph, the sentence says, the committee also noticed that the project was halted due to, can't see the sentence. There's a punctuation, or the rest of the sentence is missing somewhere.
Is it the last paragraph?
Can you see? Yes, it's the third last, where it says the committee always also notes it's due to uncertainty while the rationalization project. So there's something missing from that.
Yes. And I think people who are part of that delegation can assist us, because it's difficult to just know what was happening here. Ms. Silstone, do you still remember?
Sorry, Chair, I wasn't on that part of the oversight reports. Oh, yeah. I think it just meant it's a while is the wrong thing. It should be the committee also notes that many projects were stalled due to uncertainty regarding the rationalization project.
Yes. Okay, thank you very much. 28.
Honorable Wilma has her hand up again, Chair.
Honorable Newtruchen.
On page 28.
28, yes.
The first paragraph on page 28, the Roman figure X, first line, so that the courts can run. Could you use a different word, such as so that the courts can operate,
yes,
rather than run?
Yeah, I think that will be fine. Okay, thank you. Let's proceed. 28, 29. Okay. Thirty, 31. Thirty-two. 33. 34. 35. 36. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 47. Firstly, I think I would suggest to members that we must, in preparation for the meeting with the two ministers, we should read the two reports. And I would appeal to leaders, to leaders of the delegations to just make phone calls to check in the areas that we have visited so far, whether there has been any improvement, even in terms of the undertakings that were made by both Justice and Public Works on the areas that we have identified. I know Mpumalanga is Honorable Horn, who has already visited it. Honorable Ramolubeng for Limpopo just make a phone call just before the meeting to check whether there has been any improvement between that time we were there and today. Honorable Jere Gauteng, Honorable, but we have not yet visited Northwest. I think Honorable Breitenbach and Honorable Janji would do the same for the coastal area, the coastal group, so that we have an up-to-date information for engagement with the Minister of Public Works and the Minister of Justice and Correctional Services. Members, the report is before us. Is there any mover for the adoption of the report as corrected?
Chair,
Chair.
I move for the adoption of the report with the corrections, yes.
Mamujele moves for the report of for the adoption of the report of justice as corrected. Any seconder?
Chair, it's Honorable Wilmer.
Yes.
I would second, but I wasn't there, so I think somebody else.
No, but you can't second. If you are not there, any seconders?
I'm in the same position, Chair. I didn't attend all of them, so I can't second.
Okay, so what do we say?
Chair.
Honorable Mola seconds. Any objections? No objection. The report is agreed to. Thank you very much. As we agreed last week, that Honorable Breitenbach and Honorable Janji will take us through the preparations for the workshop. Can I now hand over to them?
Honorable Janji online.
You can proceed, Honorable Breitenbach.
Thank you, Mr. Chair. Yes, the appointment will be made. The workshop will obviously be on the virtual platform, and it's been left to JICS to decide what they want to present to us in the workshop. I've told them that they must come only with the most salient points that they wish to have addressed by the committee in order to address the issues that they're having, and that when they raise these points, they must also raise what, in their view, would be workable and achievable solutions in the short, the medium, and the long term. And then committee members will have the opportunity to engage with them sort of per category. I think everything is under control. I think I spoke to Judge Cameron yesterday, as did I, and as far as I'm aware, everything is on track and we're ready to go.
Okay. Okay, no, that's good. Any questions, members? One question on my side, have we invited the Deputy Minister of Justice and Correctional Services? Because I think there is a particular section that is not being used by heads of various correctional facilities, even to deal with the issue of overcrowding. I would have thought that ensuring that both justice and correctional services are taking part, so that we have, because I think there is a direct impact that is caused by justice, because its sentences, not justice, the court sentences But there is a particular clause in the, I think, Correctional Services Act that is not being used. Whether we have invited them.
Chair, no, as far as I'm aware, they have not been invited. And if you bear with me with respect, I think it's best we don't invite them. I think there should be an open, honest, and dealing with raw issues situation between the committee and JICS. And I think as a committee, we can raise these issues perhaps at a different meeting with the other stakeholders. We can invite JICS back to that meeting. But for the purpose of this workshop, I think it would be most constructive if it was members of the committee and JICS presenting with no other role players involved. So if we don't get sidetracked and we don't pursue other issues. So this workshop, as I understand it, is to deal with issues that JICS is finding insurmountable in the carrying out of their mandate, and the oversight body over them finding ways to deal with those issues and taking the matter forward. We can, I hold the view that we should take it up with other stakeholders at the appropriate time, but I'm not sure that the workshop is the appropriate time. But of course, if you want them there, we will invite them to.
Okay. Members, I think as a first discussion, we will have it with JICS, and then after that, then the workshop will decide how to take issues forward. Any other issues of clarity with regard to logistics of the workshop? I see none.
Chair, sorry, Chair, I'm trying to.
Okay.
Yes, Chair. I've missed the dates, maybe, of the. Have you already decided the date? Maybe I missed that one.
Yes, yes, Honorable Bredenbach, but it is on the program. I think the two workshops are reflected on the program. Is it on Friday, Honorable Bredenbach, or when is it?
I'm just checking now. I think it's on the 11th. Yes, next Friday.
Next Friday, yes.
One is on the 23rd.
Yes.
Yeah.
So we will be having two workshops, one with JICS and then one with Professor Muting of the Western is that will be dealing with issues of NPA. This one deals with issues of JICS and correctional facilities. In fact, no, let's say JICS, and with it might have some emphasis on the minimum sentences. Any other question?
Do we just have time? Is it the whole day? Time for the workshop?
Honorable Bredenbach.
Sorry, I lost you there for a moment. Can you just say that again?
The time, when is it starting and when is it ending? Is it for the whole day or half a day?
It's planned for the whole day, Chair. If we finish early, it's a bonus.
Okay, starting time?
I'll have to check with Sia, but I'm assuming 9:30.
Thank you very much. Sia?
Morning, Chair, morning, members. When I spoke with the judge, the workshop will be virtual Friday next week, starting at 9:30. Ours is just to create the link and share the link with the members and the judge. In terms of time, the judge said, I think JICS will use about an hour or so just to start with the presentations, then engagements will flow from there. So I'm not sure, it just depends on how long will it take, but that Friday it's open for committees as far as the Parliament program. Before I close on this one, will we engage about the other workshop, Chair, with Professor Mounting, or after we finalize these engagements in this meeting? So there are some few clarity questions that I need to ask you.
Okay. No, firstly, I think let's finish this one. So we'll start at 9:30. There'll be at least appropriately 1 hour given for the presentation by JICS, and then it will be followed by engagements. We don't know how long will they take, but we are preparing for the whole day's meeting. If it ends early, that's fine. So that is Honorable Maseko Chele.
We are going to get a presentation before that day. And also, I just wanted to find out, is there anything that we need to prepare? Do we have to go through the what is it? The jigs thing, what is it? Is it an act or what? Or anything that around issues of correctional services? Thank you, Chair.
Thank you. I think members, we should not approach it as a committee meeting of just a question and answers. It should be a workshop where we should come with an open mind. They would make presentation just as a guiding thing, but we should generally be coming there to say what has worked, what is not working, how do we take issues forward. And sometimes it will help us to challenge even the views that we have held for a very long time. The direct link between those views that we might have and the reality on the ground, whether there is no need to do some level of a doctrinal shift. So we must come with an open mind. It will be a workshop, but we must not be tempted to view it as a committee meeting. I think Honorable Breitenbach, Honorable Janji will be more of facilitators. It does not have a chair as such. It will have a facilitator. So it must be a real workshop. I'm not sure whether am I misrepresenting it, Honorable Breitenbach?
No, Chair, you're absolutely correct. Thank you very much. I would suggest to members, if in preparation for the workshop, the committee has been dealing with this, grappling with these issues. So perhaps just refresh your memories about the issues that have been raised by JICS and the committee about how we think we should amend things to improve them. Also, our own experience as committee members on oversight visits, we've seen what we've seen. And perhaps just do a little bit of research on international best practice with similar institutions in other countries, both in Africa and elsewhere, so that we have that we can engage meaningfully with their presentation. I have not asked for their presentation up front simply because it's a workshop, Chair, so that we don't get tempted into, as you say, preparing and coming with preconceived ideas as opposed to grappling with the issues as they arise.
Thank you very much. Committee Secretary, I'm not sure whether I see Bonani.
Thanks. The judge committed into sending a presentation and his overview, Chair, just before the day. He committed this morning that he will send the documentation before Friday, but he didn't say what specific day, but he did make a commitment. Just to clear. Thanks, Chair.
Thank you very much. So are we done with the JICS one? I think so. Sia, you wanted to raise something on the other workshop?
Yes, thanks, Chair. When I spoke to Professor Mountain this morning, we wanted to find out what topics would the committee be interested for him to cover. I then suggested that he sends the range of topics, and then members will, who's going to send it before end of business today, and then we'll forward them to members, for members to make those selections, and then we send it back to him. And the other question he had was, will the workshop be in person, or will we do it on a virtual platform? And he emphasized that the in-person will be more informative. So that's the decisions that the committee would want to take. I think there are house sittings on both days. We've set aside, I think, the 22nd and the 23rd, and both days there's sittings, but I think the sittings are hybrid. So I wanted to double check those just to bring you, especially with the issue of the venue. Will it be virtual? That's the decision that the committee still needs to take, or will we be in person? If it's in person, where likely would the committee want the venue to be? Thanks, Chair.
Chair, may I add to that?
Can you repeat, Ms. Honorable Bredenbach?
May I add to that?
Yes.
So I've had discussions with Professor Munting, and I've asked him to supply a list of the most pressing topics that they want to discuss. I would urge committee members again to think about our engagements, again, think about our oversight, think about the problems that we're experiencing in various departments of which we have oversight, and more particularly DCS, and in that way prepare. Also look at international best practice. But when he sends the list, it will be distributed so that we can mark those that we think are the most important matter but it's a 2-day workshop. We should be able to traverse most things. I did ask Sarah to try and make an in-person workshop. I do believe that it will be very beneficial for it to be an in-person workshop. And if there's no possibility of space at Parliament, then I'm quite sure that Professor Muntingani has offered can find accommodation for us at the university. So it should not be too much of a problem.
Members? But if there are sittings, then there will be just logistical issues. I'm not sure what is the problem with virtual, because even virtual, you can even have commissions. We have done that previously, I mean, as various parties, because from the venue to Parliament and all those things, it becomes sort of a nightmare.
If the members prefer a virtual meeting, then that's what we must do, Chair. I just think that possibly we'll get more out of an in-person, but it's up to the members, of course.
Yes, no. Let me hear what is the view of other members. Honorable Charlie?
Yeah, I think visually will be the best. If we will be able to do it on the jigs, I think we can do it on that one too. Less logistic problems. Thank you, Chair.
Yeah, maybe we might at an appropriate time, maybe before, I think early next year, have just for members to get together and maybe have something without house sittings where we can meet in person, maybe to plan for the year. But these house settings, for us, they pose some challenges. But is there any other view? There is a view of virtual. There's a view of in person. Any other contrary view? So, Honorable Bredenbach, can we try and make it virtual? But we do, I think the underlining is that at some point we do have to meet one another in person. We would, we will try and make arrangements. And I think part of that is that, which has, I think you have raised this issue of international best practices. I think the 2 workshops, they will also assist to inform the oversight areas that we might also need to do in terms of a study tour early next year as the committee to look at some best practices. I think these 2 workshops would also help to assist us to identify those areas and countries that we might need to visit.
Yeah, I'll do that.
Thank you very much. Members, I have received correspondence which is going to be circulated to all of you from the Speaker's office. We need to nominate a person who will sit on the review committee that will be advising the Minister of Justice with issues of, I think, equality. I'm advised that the person who was nominated last time was Honorable Stole, who sat on that review panel. So we have been asked again since that her term came to an end with the 5th Parliament that we need to nominate a person who will do that. So I suggest that next week we will do that, to nominate a person who will represent Parliament or the National Assembly in that committee. So Bonan is going to circulate that correspondence so that next week we can come back and finalize it. Thank you very much, members. The meeting is adjourned.
Thank you, Chair.
Thank you very much.
Chair.
Thank you.
Bye-bye.
Bye.